in the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. The challenges of new technology. All right, this is S-1-SC-39493, Sanchez versus Presbyterian Health Service. Entries of appearance, please.
Barry Berenberg for the immediate superintendent of insurance. Carlos Castillo on behalf of General Sanchez.
All right, thank you. Look, appears, Mr. Cooper, that you will use 25 minutes of time for the opening argument, and that amici will provide the rebuttal of 5 minutes.
Your Honor, the amici was separately speaking, and we allocated 5 minutes of our time. So I assume that they would follow us and have a chance through.
No, I mean, then nobody gets rebuttal. We can switch the order, but then,
Right, I was just, whatever works for the court. We were not aware that we had in our email this request from other times.
you do indeed.
Okay.
All right, we will put all of the petitioner's position arguments before we hear from the respondent. All right, Mr. Cooper, you can proceed.
May it please the court, my name is Ben Cooper, and I represent the qualified healthcare provider defendants in this case. Since the Medical Malpractice Act's passage almost 50 years ago, the term occurrence has played a crucial role in ensuring fair, consistent, equitable, and well-funded compensation for victims' injuries. Occurrence has always been understood to refer to the patient's injury because the injury is real. It's what affects.
When you say always,
Yes.
the briefing is replete with things like always or never, and this is both sides of the argument here.
Right.
No support.
Your Honor, the support comes from the declaration of David Barton, who was the general counsel at the time of Baker versus Hedstrom of the Patients' Compensation Fund for the superintendent, saying that that had been the consistent practice.
So we're going to take an affidavit from a general counsel, former general counsel, doesn't speak for the body, and on a question of law? When is that ever done?
Your Honor, I'm simply explaining, he was the general counsel at the time he wrote that affidavit. I'm simply explaining that's what the administrative understanding was.
That's
This
not
court,
the administrative understanding. How is the general counsel affidavit the administrative understanding?
he was offering on behalf of the superintendent.
So if the PRC comes into court on a question of law, we can take an affidavit from their general counsel?
Your Honor, this court can give whatever deference it wants or no deference at all.
I
Well,
appreciate it.
assume with me it's no deference.
That's fine, Your Honor.
So
We're
what
happy.
support statements like always, and I'll be pressing on Mr. Hunt on this too, like never. We have all of these bald assertions in the
I understand
briefing
completely.
about what the landscape here is, that there are no cases, this is going to be limited to one case, or, oh my God, the sky is falling.
Your Honor,
Where does reality land?
the one time I'm aware of in which case this issue actually made it on appeal was in Baker versus Hedstrom, where it was brief, but then the court ordered the parties to mediate, and it ultimately settled. So it's never been resolved by an appellate court in this state.
That's a different question.
I understand that, but I'm simply relating this struggle over the meaning of occurrence has gone on for a very long time without definitive resolution. That much is true, and I think everyone would agree with that. And that's one reason.
Do you think it's a struggle as opposed to crystal clear?
I'm sorry.
You think it's a struggle as opposed to something that is crystal clear?
It has been. It is. If the continued debate over it is an indication of ambiguity, then it's ambiguous. but we don't think it is. We think if you go through sometimes issues should be capable of definitive resolution, yet somehow they evade them and parties do their best to argue both sides. But we think the language of the statute, even before the 2021 amendment, establishes our position. So
Hasn't that resolved the ambiguity, the 2021 amendment?
we believe it does. There are two ways.
So why does that not apply here?
We think it does apply here, but there are two ways to cut it. Since the plaintiffs are arguing that that does not apply retroactively, there are two ways to approach it. We think each way produces the same result. One can look at the pre-2021 statute, as the 1992 version, and read it and come up with that occurrence equates to injury, a single indivisible injury. Or one could approach it from the 2021 amendment and say that applies retroactively as a clarification.
Retroactive,
Certainly.
because I am struggling with are you suggesting that we hold that all the amendments are retroactive? Or are you asking for a piecemeal portion of the amendment, which is just of course, the definition of a
Definition.
So that takes me, that's what I thought you were asking for. And I'm wondering where we draw the line. If you're saying, well, one part of this statute, I want you to declare retroactive, but the rest of it's prospective. And does that leave parties wondering in the future, well, is this portion possibly retroactive? Is this portion? I'm a little uncomfortable with this.
I understand.
Approach. And how do I resolve that?
I think you resolve it by looking at what the amendment is. There are certain provisions that are certainly not retroactive. Increasing the amount of the cap, not retroactive. The legislature was quite clear about that. The question is, one looks back to this court's case law on amendments that are clarifying, and those are deemed to express what the law always was. So they have, you can think of it as either a clarification or as actual retroactive application. But we think under this court's decision, Aguilera versus Board of Education, where the legislature leaves the operative language of the statute alone and adds a definition that applies, that clarifies.
So you believe that all the amendments are prospective except for the definition of?
Your Honor, there are a lot of amendments in that statute. I haven't looked at them.
And that's my concern, is that we don't give the public or the practitioners notice if we start piecemealing pieces to apply retroactively and then others not. That's my.
To be honest, I'm not aware of any other amendments that are clarifying in effect. A lot of the other ones are direct changes in the procedure, changes in the status of the fund. I don't see the one clarifying aspect of the HB 75 was the addition of the interpretive guidance and the definition of occurrence. That's the only one I'm aware of, and that is treated differently because of its clarifying nature and the fact that we know what we're dealing with that statute.
So I'm going to take you both to some language from Wood and Pena and then Aguilera.
Okay.
Because it's talking about the word clarification. That's to clarify what was previously implicit in the law.
Right.
And that's directly from Wood, citing Pena. And then you just brought up Aguilera. And Aguilera, what was previously implicit in the law arose in Aguilera because the courts had repeatedly defined what just cause meant. And so the legislature simply taking that which the courts have identified as just cause and putting a definition in the statute. And that's what gives rise to the quote in Aguilera, such a modest step is not usually a harbinger of radical change. Those are not the facts here.
But in a sense, the facts are better because the clarifying.
An undefined, ambiguous term, not interpreted by the courts, is better situated for the implicit in the law.
Because the definition that was added, I believe in 1991 in Aguilera, of just cause was a very limited definition. But the court nevertheless read it because it was just an added definition, read it to include what was the Swisher Compromise that had been announced in 1955, saying just adding a definition didn't change it. So even though the definition seemed more restrictive of what was just cause and didn't include on its face the Swisher Compromise, the court said, well, we're not going to see from the addition of a definition any intent to change what the law had always been as defined by the courts. In this case, the definition is consistent. That is, the definition is not more restrictive than is needed to apply to this case.
That doesn't follow in terms of, I mean, Aguilera, yes, they're relying on the compromise in part, but they're also relying on the fact that every court that had addressed the issue had defined just cause in that manner. Here we have no
That's correct.
pile of courts defining it.
I agree with Your Honor completely about that aspect of it. But the other aspect of it was it appeared on its face that the statutory definition that was added was more restrictive than the judicial precedent. Nevertheless, the court said that the addition of a mere definition would not be read to have changed the broader body of law that had developed. So in this case, we don't even.
You're not, I think you're missing the point of my.
No, I understand the point. I understand you're absolutely correct, Your Honor. I understand your point. I'm saying there's it's not exactly the same, but it's a different way of looking at it, in that if you look at the way the definition relates to what
here
priesthood.
was implicit all along, forever in
Okay.
time, in the
And
law.
that's why I was going to start with the language of the 1992 statute. That is, it says that the operative language has remained the same. The aggregate amount recoverable by all persons for arising from any injury or death to a patient as a result of malpractice shall not exceed $600,000 per occurrence. The statute does not refer to active malpractice. It doesn't refer to provider. So neither of those bases. The only thing that it refers back to, the only referent for that phrase is any injury or death. Now, it can't mean provider because occurrence is a thing that happens by its nature, whatever it is. A provider is not a thing that happens. A provider is a person. So the district court, unfortunately, was trying to come up with a compromise, a middle number of caps that would apply. Not as much as the plaintiff wanted, not as much as.
Who is, I mean, I don't even know which path the parties are trying to assert is correct if we dig into any kind of merits here, because we have the plaintiff's position, the defendant's position, and then the O'Connell compromise, as I have been thinking about it.
I think that's an accurate way of thinking.
You know, it was a splitting of the baby. So what path are we to go down if we've got three reasonably intelligent positions all going a different direction?
I think there is the position that we think our position squares with the wording of the original statute, because occurrence, the only referent that it could be relating back to is any injury or death. And if you look at textually, the plaintiff's argument is, well, that means per occurrence is surplusage. And it isn't, because any injury or death, as the courts we've cited have indicated, any is an ambiguous term because it could mean one or all, depending on the context. And so per occurrence means it's per injury. So if you have multiple discrete injuries, you could have multiple caps because there are multiple occurrences.
Go ahead. Mr. Cooper, isn't all this hypothetical? In other words, we're assuming each and every one of these healthcare providers can be liable for over $600,000, meaning they were negligent and approximately caused $600,000 of damages, exclusive of future medicals and punitives. And why not wait for a trial to see where it all shakes out and preserve the issue if it so happens, preserve the issue through instructions or interrogatories, and then argue the issue? It seems like
I think this is an unambiguous case or a good vehicle to decide it because of the facts as alleged.
But I think going to the senior justice's point, why interlock it at this point? What is the question of great public importance that we're reaching here, given that it's been settled, at least going forward? What's the universe of what's left that would cause us to do this in an interlocutory?
Because, Your Honor, this case and all the other cases that have been filed where there are allegations of multiple caps are the tip of the iceberg. The iceberg being all the case claims being made.
where's the data for that?
I think it's in the superintendent's amicus brief. That is, there are a lot of cases where there are allegations. And most cases, as the court would expect, settle at some point. And it makes them unsettlable until the legal issue is resolved.
Except they've been settling all this time.
Well, and Baker versus Hedstrom ultimately settled, even though the issue was, and I can't, I believe the terms are confidential, but this issue has evaded review time and time again. Yet this quandary goes over, and one could.
Evade review if you took it to trial, the judgment was more than $600,000, and then we had to decide. Then we would have to decide the case.
Well, that's what happened in Baker, and the case was fully briefed, and then the Court of Appeals said, we're requiring you to mediate this, make it go away. And so even though that's what happened, there was a ruling, there was a judgment, and we were on appeal.
Isn't it more appropriate for us to be deciding this issue after we know there's an issue? If the judgment for the plaintiff is less than $600,000, there's no reason for us to decide this today.
Your Honor, the issue continues.
But it's finite.
Well, it's not finite, because depending on whether minors claims, we could have these claims for another 20 years.
That's where both sides are painting a completely different picture, neither of which, and I'm going to have to disagree. I don't think the amicus does provide a lot of data. I don't think anyone's provided data. Is this really something that's going to keep happening and clogging our courts? I just can't, haven't been a lawyer, a real lawyer, like where you go out into courtrooms in so long, but I was trying to think in my mind, how often are these cases coming up where there's multiple healthcare providers that are being sued, and that these have this exact same kind of issue that are going to be coming up from prior,
The superintendent's data in their amicus brief was, over the last several years, there are between 3 and 7 cases alleging or motion practice pursuing multiple caps for each year.
Mm-hmm.
So that's the data we have. I represent individuals in this case.
Another procedural question.
Certainly.
On Senior Justice's question. If this were to go to trial and the jury awarded the injury, strike that, the jury found the injury, the dislocation, and found damages, could the plaintiff recover from each doctor for that same injury? Would that be resolved post-trial?
We believe they could, that it would be subject to the one cap. Because these facts are rather straightforward. Child falls on May 2nd. 3 doctors then over the next 2 months, and in most cases, shorter period of time, read different sets of x-rays. One that day and the next day, one 10 days later, one later. And then the allegation is that the child grew over the next 3 years, and then in 2017 started to feel pain. So there's no allegation of that, the failure to diagnose on May 2nd was exacerbated by the failure to diagnose.
They're going to award damages for that, assuming they do.
Right.
That we're down the road. They award damages.
Yes,
Now that's a damage for that injury.
for that injury, that's correct.
And that child could recover from different providers, you believe, for that same injury.
Subject to one cap. So it may be allocated among the different doctors who are held to be negligent, but it's still one cap. And to be honest, Your Honor, to be completely frank, we are again before this court with the fully briefed legal issue of whether under the statute as it initially read or the statute as amended, and whether it applies retroactively. This is the time for the court to provide guidance so that this issue doesn't have to percolate and go unresolved for another 5, 10, 20 years, depending on, because of the problem of minors whose claims will not accrue until they age of majority. You could continue to have these from time to time over time. And now is the time to decide the issue. It's a very straightforward, narrow issue.
Does timing have anything to do with the analysis? So here we have, I think, facts that are kind of convenient to your argument. You have a radiologist close in time repeating an error, and then we have this passage of time and growth and now this injury. But what if it was Dr. 1 diagnoses somebody with stage 2 cancer, 6 months later, another doctor diagnoses with stage 2 cancer. 6 months later, still stage 2 cancer, and then lo and behold, it's stage 4. And the treatment protocol would be different, and the lost chance of life
Mhm.
would be different based on these extreme periods of time, but it's still one injury. What do I do with
Well,
that?
it's an exacerbation of an injury. So even the current, the statutory definition which was added refers to if separate acts or omissions cause additional or enhanced injury or harm.
But what about under the statute in place at the time?
We would submit that that's the same, it's a clarification that it's the same analysis.
What if I don't,
Even
what if I
with-
agree that, what if my position is it's not retroactive and I'm forced to
Right.
define the statute that existed at the time?
We would say the injuries are different, but it would be a
I
factual
have to
analysis.
take your word for it? that
No,
you
no,
would take
that is, I think, if you read any injury or death, that a single indivisible injury is, that's the way, if you look at Lujan, when you have,
Yeah, but I'm talking about a single indivisible injury being, oh, shoot, this was stage 4 cancer. But you have this extreme passage of time between the malpractice committed by different providers.
that would have to be argued based on the evidence of whether there was evidence establishing that there'd been an
So the
exacerbation.
definition here would just leave the issue open all
Well, that's
over
always
again.
been the issue of whether you have concurrent or successive tortfeasors. That is, whether or not there's been a tangible, discernible exacerbation of the injury such that the second one becomes a successive tort.
Are the plaintiffs here arguing that it's successive?
They have not yet argued, I can't speak for the plaintiffs, but the pleadings we have in
And
the case.
if they amend their pleadings,
Well,
will
they,
this all amount to a hill of beans?
no, but, well, at least we know what the legal rule is. And if they want to amend it,
For one set of particular facts.
well, but the issue of successive versus concurrent tortfeasors, whether it produces a single indivisible injury or multiple injuries by virtue of an exacerbation, has always been the question of, in a number of contexts, not only caps, but also successive tortfeasors.
It's just pointing out that I think the argument that's being made here does not settle a whole lot, because this is a very fact-dependent case. And again, the facts here are easier for you to argue, for your client's position, than a more nuanced set of facts that
Right.
might lead us in a different direction.
We're arguing for the predicate legal rule, and the parties and the lower courts don't even know what the rule is. That is, are you looking to see if there is an act about different acts of malpractice, or are you looking to see whether there are multiple injuries, that is, divisible in multiple discrete injuries? So we don't even know definitively what the rule is or what we're supposed to be looking for. And this court could decide that and then leave the parties, in this case and other cases, as they always have been left, to litigate whether or not you've got one single injury and therefore one cap, or multiple discrete injuries, whether it's an exacerbation or a completely separate injury, and therefore multiple caps. But at least we know what the rule is. Right now, we don't know what the rule is, what the legal principle is. And this court can decide the legal principle and then leave the parties, in this case and all the other cases, to decide it. And the trial court's ruling below, that it was per provider, shows the lack of clarity in the lower courts as to what the legal rule is. So tell us what the legal rule is, and the case will probably never come back. But a lot of other cases may be able to be settled because at least people know what legal rule they're applying to the facts in that particular.
Those future cases may be nuanced in ways that the lawyers then argue, well, ours is a different definition of occurrence because a different set of facts, different circumstances.
I think
And then
that-
we're back to square one.
I don't think so, Your Honor, because this is not my first case involving this particular issue. I was also counsel in Baker versus Hedstrom, and that was multiple hospitals failing to diagnose an ongoing heart attack over a period of time. And this court decided Baker in another decision on another legal issue. But no matter what, and that was a more complicated set of facts because there was an argument about exacerbation by later doctors of the failure to diagnose the young woman's heart attack. But still, you would know what the legal rule was, and you would know what you were trying to apply. Here, we don't even know what the legal rule is. And the trial courts compromise as doing it per provider shows there is a long felt unmet need for a resolution. What is the legal rule that we're supposed to be applying on whatever fact pattern is?
That's not a binding decision. You could go down the hall in the second judicial and get a different determination a week from now.
Absolutely. Absolutely. We have no binding determination. That's the problem. We've had scattered trial court
That's
rules.
how law is developed. It's not normally developed through interlock, I think is the questions from here. We don't disagree with that. The question is, does that rise to the level of great public importance? So we should take it right now.
We think it does. And at the very least, the legislature's act of passing an actual definition, and whether or not that applies retroactively to prior cases as a clarification, is something this court can decide. So at least we know in the trial courts, either it decides or what body of law we're operating on. That's a purely legal determination. And whatever guidance we get from the court, allows us to resolve cases. Now, to be honest, we think regardless of whether you look at the 1992 statute standing alone, without looking at the later definition that's added, or whether you look at the later definition and decide whether it applies retroactively, you come to the same place, because the legislature's resolution, it reflects what a lot of us, I don't want to get into an argument about the superintendent, Mr. Bernberg can represent the superintendent, what was thought to be the law in a lot of cases before. But this is the time when the court can clarify that and really close the loop that the legislature closed moving forward, and close it looking backwards, and put us all on the same page. And then let us go litigate the cases on the facts as we find them.
What if we were to agree with the plaintiff in this case and come up with a definition that's contrary or not exactly to what the legislature came up? Where does that put us?
If it's different, I think it would be the incorrect definition. I think there is.
That's your opinion, but
I agree. That's my argument, Your Honor, is that there is no basis for using active malpractice as a referent for per occurrence in the words of the statute.
But is there anything that prohibits this court from coming up with its, whatever the definition is, and it may slightly diverge from the amendment? And I don't believe that there's anything in the law that prohibits this court from doing that. Yes, it creates two classes based on what we would then be saying is,
Right.
is something that wasn't retroactive.
And as far as I know, this court would depart from all the other state courts that, in construing their acts, had said that occurrence in CAP litigation.
I don't think we care so much about
I understand that, Your Honor. This is not the first time I've argued an MMA case before this court. But so,
your time has expired.
thank you very much.
Thank you. Mr. Fahrenberg.
May it please the court. Barry Barenberg on behalf of Alice Kane, the Superintendent of Insurance, appearing as amicus. I'd like to address the question of the public importance of this issue. So we're talking about what the patient's compensation fund might pay. It pays unlimited past and future medical expenses, no cap on that. We're talking about the non-medical damages here, which is per occurrence, and there's a cap. The providers pay an initial $200,000. Once that threshold is reached, the patient's compensation fund pays up to an additional $400,000 for a total of $600,000 capped per occurrence. Now, the Plaintiffs and Trial Lawyers Association argue that if you have multiple occurrences, the PCF is actually likely to pay less. And the reasoning is you now have, as alleged in this case, 3 occurrences, 3 providers. So there are 3 $200,000 caps that or thresholds that need to be met. And so that leaves nothing. You had $600,000 in damages. It's all covered by that threshold. So there's nothing for the patient's compensation fund. The problem, Your Honor, is that the non-medical damages are not fixed. They include things like pain and suffering, loss of consortium, which even the uniform jury instructions say there's no fixed method for determining them. It's up to the jurors to use their own judgment. And so what happens in these cases is during the negotiations, the settlement, and most of these cases resolved during pretrial, is the plaintiffs allege uncapped damages, that there are a number of providers that aren't covered by the MMA, that this isn't medical malpractice, it's a violation of the Unfair Trade Practices Act. These are actual examples. And of course, punitive damages. And when you look at those uncapped damages, you have $200,000 threshold versus punitive damages and others. And so the $200,000 is not much for the providers to pay. And so all of the providers then say, we better pay this $200,000 to get out from it. And then the parties together, the plaintiffs and the defendants, agree that the patient's compensation fund should just pay the additional $400,000. So suddenly, when you have 3 occurrences, you get the $200,000 paid pretty quickly, and then without the superintendent's participation, it goes up to $600,000. The parties then take that to the trial judge, and the superintendent, again, is not a party, can't appear, and so the only check on whether this is a reasonable settlement, and the only people who give input to the trial judges are the parties who reach the settlement agreement. And so there's a settlement that's approved by the court, and under the MMA, the patient's compensation fund, the superintendent has no choice but to pay that. And what's actually happened is, in some situations, the parties have then taken this to another judge seeking a writ of mandamus to force payment. So if you look at that, the overall payment in any one case that the patient's compensation fund has to make goes up. And the way that gets covered is the surcharges increase. And when the surcharges increase, the overall cost to the providers of their medical malpractice coverage goes up. Now, the studies are discussed in the amicus briefs as to what impact that has. And yes, the studies are mixed. In some situations, an increase in malpractice costs doesn't affect the providers. But in other situations, the study shows that it does. And where it particularly has an impact on the providers is in rural regions and in high-risk practice areas. And that describes New Mexico. So this issue comes up every year before the legislature. There's debates about the Medical Malpractice Act, and there's extensive coverage about how this affects the medical providers in the state, and thus how accessible medical coverage is for the citizens of New Mexico. And these show every year that it's harder and harder to get an appointment with your primary care physician, that it's harder to find new practitioners if, for example, you need to see a specialist, and that rural areas of New Mexico, especially outside Santa Fe, Albuquerque, Las Cruces metro areas, are becoming healthcare deserts where certain types of medical needs can't be met locally. One prime example of that is in OBGYN. That's a very high-risk area, and that's where a lot of the practitioners are forced out by the increased cost of medical malpractice.
How many cases right now are pending where the definition of an occurrence is at issue with multiple covered medical care providers?
So at any one time, there are a bit over 500 cases pending. And it's hard to say how many of those involve multiple occurrences, because they will start out with a single occurrence and then it goes into mediation and the arguments are raised, well, there's multiple providers, there's multiple injuries, and so there's going to be multiple occurrences. So it happens quite frequently. I provided the data.
In other words, is the scenario you've described the cause for having these desert areas for OBGYN practitioners in rural areas? This precise situation.
Well, the problem, Your Honor, is we can't say that just this one thing. There are lots of parts of the patient's compensation fund. There are lots of pressures on it, and they all combine together. So the superintendent's the only one that has sort of this bird's eye view of the patient's compensation fund. And it's the nature of litigation that you only get one issue at a time. And so if you ask me, is this one issue going to destroy the patient's compensation fund? And I can't say for sure, and I don't think our experts would be able to say that. But if you can ask the question, well, all of these other pressures, and I pointed out some of them, the non-medical malpractice cases, if you put all those together, the combination of those is what's causing the problem. And we have to deal with each of the pieces. And so each one adds some pressure to it. I'd like to, oh, my time is up, I'm sorry.
May it please the court. I'm going to start by saying that we believe that Judge O'Connell got this issue right. And I know that you earlier were talking about sort of the 3 options that came up in the Judge O'Connell compromise. And the reason that she got it right is because she based her ruling on two things, which is a plain reading of the Medical Malpractice Act in its entirety, plus a review of the case law. And the case law dealing with the plain meaning critically is Cummings. And so where does the issue of per provider, as it's essentially been coined by this court, where does that come from? Excuse me. 41-5-6, -3 is the definitions section of the Act. And what's defined in the definitions section, in addition now to occurrence, but previously, is malpractice claim. And that's a critical definition. And the reason it's a critical definition is because it states, and it was C in the old Act, it's G in the current Act. And it says malpractice claim includes any cause of action arising in this state against a healthcare provider for medical treatment departing from the standard of care. So what we have in the Medical Malpractice Act first, and this is in the old Act, and this is in the current Act, is malpractice claim is defined per healthcare provider. It does not say defined against all healthcare providers. It does not say against any healthcare providers. It says distinctly a healthcare provider.
That is negligent and proximately causes the injury to the patient.
Yes, sir.
So how does that fit this case? You have an injury, three or more medical care providers.
Yes. And the way that it fits in this case is you still have medical malpractice claims against three separate healthcare providers. Each of those separate healthcare providers committed an act of malpractice separately, not at the same time, not in the same procedure, at separate times reading separate x-rays. Each of those individual negligent acts are a malpractice claim. The fact that those issues came together to create an injury does not change the definition of per occurrence. It does not in any way within the words of the act that was in existence at the time that this injury happened. It does not go back to injury. There's nothing, and that is why, because malpractice claim, I think if the legislature had intended what is being asked by the petitioners, there are multiple ways that could have happened. It could have happened within malpractice claim. They could have said against all healthcare providers, which they did not do. And I think they also, and we've made this argument, and certainly you understand it, they could have taken out the phrase per occurrence. And instead, what did they do? What they did in 1976, which is really at issue in front of this court, is they used the common definition of per occurrence. The common definition used within legal proceedings, which is per incident, per event.
But it's got approximately cause. And the problem I'm having with that argument is that it seems like there's one injury. Three different people approximately caused an injury, and maybe comparative fault or comparative negligence may be playing a role, but that doesn't change that this patient has one injury.
You're absolutely right. And I don't disagree with that. And I'm not going to stand in front of the court and argue contrary that there are separate injuries. But I will very much say, under the act that was in existence, this court doesn't have to get there. And the reason the court doesn't have to get there is because per occurrence is not defined based on injury. Malpractice claim is not defined based on injury. It's defined based on an act of malpractice. Yes, the act of malpractice has to cause injury.
That's in the definition.
It is. It cause injury. But multiple acts of negligence can cause one injury. I mean, it's not different than, if we're talking about the auto industry, the auto insurance industry. A lot of those policies are also per occurrence, obviously a different definition, but also use the phrase per occurrence. If multiple cars hit one person, and that person passes away, there's one injury. The patient died, or the plaintiff in that case died. But
the law applicable to this case is not ambiguous. You think based on the definitions and the plain language, it supports your position? Or do you think it's ambiguous and then we look further?
Yeah, that's a great question. I've spent a lot of time over the weekend trying to think of what's my
Me
best
too.
answer to just that issue. And because I think it's an important question. As I've come back to it, what's in front of this court now, I don't believe it's ambiguous. And there's two reasons for that. And the one is because per occurrence has a common understood definition. And Cummings, we can't distance occurrence from Cummings. This issue was in front of the Supreme Court. Yes, it was on the statute of repose as opposed to multiple caps. But the issue was, in Cummings specifically, whether or not occurrence was a continuum of the act of malpractice through the injury. That was what was being offered at that time by the plaintiff, because it was a discovery rule on whether or not they had a claim. And it wasn't discovered that they had cancer until a long time later. The Supreme Court was very, very clear. They said the plain language establishes the date of the act of malpractice as the only relevant factor without any in reference to any subsequent harm. So this court has already defined the word occur within the Medical Malpractice Act. And it's defined it.
The date the malpractice occurred.
They've defined it, correct. They've defined.
There's occurred and there's occurrence.
Correct. Absolutely true. I mean, it is.
That's why the repose, I think, it does matter that they're discussing a statute of repose, or does it not?
It is, I'm not great verb noun and all that. It's occurred versus occurrence. That's absolutely true. But the root of the word is the same. And for this court to have one definition of occurred as act of malpractice in the Medical Malpractice Act, and then separately to say, well, but occurrence means injury. That puts this court in a very difficult position, because the plain language is what drove the decision in Cummings. It's the same plain language here. There's no.
Let me ask you for a minute. Let's assume the court thinks the language is ambiguous.
Yes.
Where do you go from there?
If the court believes that it's ambiguous, then we start to look at judicial decisions. Have any other courts interpreted this? Has this court interpreted it? And so I think you still come back to Cummings first and foremost. I think that is a very difficult position for the petitioner's argument in this case, essentially parsing the same word within the same statute. I understand that sometimes a word may mean something different in a different statute, but that's not the case that we have here. And separately, I think you also then look to the context of the other parts of the Malpractice Act. Is the word occurrence used anywhere else in the Malpractice Act? And it is. It's also used in terms of, formerly it was you had to have a policy that was occurrence-based, because they not discovery-based, or not claims made. It was occurrence made, which meant you had to have a policy that covered when the act of malpractice occurred. And so the definitions fit. And then you also look to, in Foles, this court dealt with single occurrence under the Tort Claims Act. And I know this court in Cummings very specifically, or one of the cases, maybe it was Baker, said, well, our holding in Foles doesn't control the Medical Malpractice Act because it's a different definition and a different word, single occurrence. But what Foles did look at, and certainly Justice Wilson in his concurrence, was, well, what does occurrence, in his concurrence, what does occurrence mean? And he said specifically, it means incident, event, or accident. And that the injury is the result of an incident. It's not the incident itself. And so really you then say, what support is there in either plain meaning, case law, or even context for the position that occurrence in the act that's at issue in this case means injury? And there's not. There's no cases that support that. They've not been cited to this court because they don't exist.
And what about legislative intent and the other sort of legislative perspective we're supposed to look at? And how do you believe that supports your position?
Sure. So I think legislative intent is the critical issue at large part. And what we're talking about is legislative intent in 1976. And so you go back to the act, and you go back to the act first by looking at, our position is malpractice claim, definition C under the old act, where it very specifically calls it a cause of action arising against a healthcare provider. And then you also look at how occurrence was used in the previous act, meaning the aggregate dollar amount recoverable from any injury or death as a result of malpractice shall not exceed $600,000 per occurrence. So when you're looking at that statute, and obviously that's what we're struggling with the most, well, what does per occurrence reference? Per occurrence reference malpractice, because that is the one, that's its common, it references the act, the incident, per incident. And so there's nothing, when we're looking at ambiguity and we're weighing that, if this court decides, well, it is ambiguous because there's a whole lot of people here talking about it and struggling with it, then the legislative intent goes to the plain meaning, goes to the case law, goes to what's specifically relevant. And the fact that there have been, I think what the petitioner's position is, well, don't you also look at the superintendent of insurance's interpretation? And maybe you could if there actually was one, but there's never been an interpretation published either through the rulemaking process, through the administrative regulation process, through any kind of formal opinion. That's never occurred from the superintendent of insurance. Rather, what they want this court to believe is that because we claim we've always defined it that way, somehow that deserves deference from the court. And somehow that also means, more to your point, Justice Zamora, is that shows that we got the legislative intent correct. And the gulf there is that there's been no such interpretation, and that it's not even accurate to say that it's always been interpreted that way.
I want to ask you about what I think was the bulk of the argument of the petitioners, which was that we don't need to go through all of this. There's a statute now that specifically defines what an occurrence is, and that statute is only clarifying what we've all known for time in memoriam, and we can just retroactively apply that statute. Tell me why we should not do that.
Thank you. A couple of reasons. One is the body of law in New Mexico says prospective application is the default. And so there has to be a specific reason why this court believes the legislature intended prospective application. So there have been instances where that occurred. To my knowledge, those have almost always been when the legislature, one, either gives it specific retroactive application, or, as in one of the cases, gave it immediate effect because it was really important. So it's effective immediately. What we have here is very different than that.
But we do have the test that's set out in Swink and set out in several other cases that have the three elements that if you meet these, then we will retroactively apply, even if the legislature has said nothing. How do we deal with those three elements?
One, just to finish the one thought that I had, the fact that it was specifically given an entry date, January 1, 2022, 10 months after it was enacted, is clear legislative intent that they intended prospective relief. Now, more to your question, which is, okay, understood that, but what about, is it clarifying? Is this really, and it says it in the title, is this really just a clarifying amendment trying to tell us what we always intended to mean by occurrence, per occurrence? And I think that you have to take the act in its entirety, first of all. What did the legislature do with the 2021 amendment? They overhauled the Malpractice Act. They didn't simply raise the limits. They didn't simply issue a decision or an opinion on per occurrence, a definition on per occurrence. They issued a definition on healthcare provider. They issued a definition of hospitals, of independent providers. They added nurse practitioners and nurse midwives. They clarified the Baker versus Hedstrom issue and said, yes, of course, business corporations that practice medicine can be in the act. They changed the way the panel procedure operates. They changed the superintendent's role. They required a third-party administrator now. They required annual actuarial studies to set church surcharges. They put in the act that hospitals would be out in 2026. So when you're looking at the totality of what occurred with the act in 2021, it was an overhaul. To suggest that that was clarification is simply to ignore the entirety.
Piggybacking on Justice Zamora's earlier question, can we just look at what they did with the term occurrence? Do we have to look at, I agree with you, they did a lot of things within that act. And you go through the sections and some say amended, some say enacted. There's lots of changes. Can we do what Justice Zamora asked about, which was we're just going to look at occurrence and see what the legislature did with that term in terms of deciding whether it was clarifying or not?
Yeah. And Justice Vargas, I think the answer to that is no, and here's the reason why. One, it certainly creates massive ambiguity for all practitioners of, okay, which part of it is which, what's applied retroactive, what's not. But I don't think the court has to get there. And the reason is the amendment that now defines occurrence and that also gives the interpretive clause for occurrence was far more than a clarification of a definition that everyone had always understood. There were no cases that had defined occurrence, and then the court comes in and redefines it the same way as the cases did. In that circumstance, I mean, really kind of what they did with Baker. They took this court's ruling in Baker saying corporations can be admitted. They then enacted that as part of the amendment in 2021. That issue is probably clarification because they had court support for what had already been done. This court had decided corporations can come into the act. And then the legislature said, let's just put it in the act to be sure that that's not just from the court, it's in there. That's probably clarifying. And that was, you don't even have to get to retroactive on that issue because it was already in place because of this court's decision. Here, what they did with occurrence was not simply define a well-known term and a term that where there had been consensus or where there had been decisions on it. They dramatically changed, I shouldn't say changed because there wasn't it, they introduced a new definition. And certainly I would take the strong position that the definition of occurrence, when it's read in the 2021 amendments, is not nearly as clear as petitioner would have this court believe.
Can I ask you one more question about,
Of course.
about retroactivity? What do you read into the fact that the effective date of the statute, there are two effective dates. There's one effective date for sections 7, 13, and 14, which is kind of the normal effective date we would have in statutes, July 1st of the year of that the legislature passed that statute. And then we have a second effective date for sections 1, 6, 8, 12, 8 through 12, 15 through 17, which is January 1, 2022, which is this statute. Does that tell us anything about what the legislature intended?
And so, I'm sorry, so the ones that they gave immediate effect were section 7 and section 13?
7, 13, and 14.
So 7, here's the reason, I think the reason that occurred. 7 is the procedures for the medical review panel. And so that's where, when you have to file your claim first with the panel before you file it in court. The change was the hospital said, we don't want to be part of that anymore. And so section 7 pulled the hospitals out of the medical review process. So at some level, it doesn't affect substantive rights. It doesn't affect ultimate conclusions of what's available under the Malpractice Act. It simply affects that administrative step that has to occur before you can bring a claim. So I think that was the main reason to make that immediately effective is because, and it was at some level already in practice, there was real uncertainty about when hospitals have to go in front of a panel and when they don't. So I think there were, excuse me, and to your point, really, that highlights even more that if the legislature had intended retroactive or they thought it was really important or it was something that had already been known, they could have made it effective immediately, which they did in other provisions, but they didn't with the definitions section. So I think that it actually, I mean, to our view, that highlights the reason that it was the legislature never occurred to the legislature that this would be a retroactive amendments to the act.
Will you address the one of the arguments made by the petitioners here, which is it's really important for the court to reach this issue now because of continued I don't know if it's consternation or ambiguity for the cases that would fall under anything, that occurred prior to this amendment. I'd like the benefit of your position on that. I will say that I think you probably know where I'm going. Just like petitioners, your brief is really bereft of support for this idea that this might be the only case. And so I'm curious about, your thoughts in particular responding to the idea, what about unknown minors at this point? And that could be a much larger number. And wouldn't it be better to resolve this now? Do you want us to resolve it? Do you not want us to resolve it? It's not clear to me because of where you started your argument today.
Oh, I understand, Justice, and I think it wouldn't be clear to you also because in our briefing, and certainly in the Court of Appeals briefing, we said this shouldn't be taken up by the court. I mean, I'm not going to run away from that. That's why, at some level to the Court of Appeals, that was the position we took, and I think that was part of the reason the Court of Appeals, I can't remember if they granted it and then denied it or whether they just denied it. But and certainly our initial brief to this court was, we don't think it's right. And one of the reasons, I will say this, and I obviously this court, I think when you granted the writ for certiorari, decided it was an important issue. And we accepted that. So we've not raised that this morning because our belief was this court decided it was something that needed to be addressed. It's remarkable over the last several days in getting ready for this that 45 years later, and this is just now becoming before the court. It really is remarkable that this court has never weighed in on the issue of per occurrence under the Malpractice Act. So is there value in doing that now? I suspect that there is value in doing it, or there is value, clearly. How many cases that applies to, I don't have the answer to. Obviously, I don't think it's hundreds, but it matters to my clients in this case, and that's about all I can represent. And whether that's enough, I don't know. Yes.
So that's half the question, I think. The other is the timing. It's whether it's important now. It may still be important, but is it better suited, as we normally do, let the facts be developed? If a jury verdict comes in and moots this whole thing out, you get poured out. Now we are reaching into an issue we didn't have to. But what is compelling about the Superintendent of Insurance's argument is that, unlike, for example, other types of insurance, they don't have a seat at the table. In a car accident case, if there is coverage and the person that causes the injury pays out, the insurance company has a voice in whether or not they're going to fight the rest of it. What is interesting about the posture and the public policy behind the act is two parties can come to an agreement in a mediation and say, okay, I'll pay out mine and I'll leave the carrier, basically the state, for the rest. And we'll just call this type of damage. And it seems to me that is something that is a matter of public concern, because they don't, as I understand the argument, they don't necessarily have a voice on most cases that don't go to litigation.
Justice Thompson, I appreciate you raising that issue because I wanted the opportunity to respond to that. And quite frankly, I think that the Superintendent of Insurance is misrepresenting their role to this court. I have never been in a mediation involving a medical malpractice claim where there is not a patient compensation fund representative at the mediation. That's never occurred. The patient compensation fund and the underlying insurers won't set a mediation unless the patient compensation fund is represented, because you can't have one. We can't, as litigants, you can't bind a party that's not there to a settlement. So I heard that argument, but I was searching in my mind, one, for any support whatsoever for that position in the record, which there's none. And second, from practical speaking, that's not how it occurs. That's not the intent of the Medical Malpractice Act. Certainly what they talk about in there is the patient compensation fund's duties. And the patient compensation fund, for the longest time, I think there was in David Barton's deposition, it was Erla Lutz that was represented. She was the patient compensation fund adjuster for a long time. Mike Demers was after her, and now it's been handed over to third-party administrators. So there's, Integrion is who it was. I can't recall who it is right now, but there's a third-party administrator whose job it is to attend mediation and trial and make a decision on, for our $400,000, how much of that are we going to pay in settlement? How much of that are we at risk for in a trial? So to suggest that the superintendent is left out in the dark and somehow they're required to pay all these claims is simply not reality. And so in terms of the sky is falling kind of argument, I think there is not support for that, first of all. And for this court's concern, that issue is addressed through claims handling, through the third-party administrator, and through the adjusters that are there on behalf of the patient compensation fund. Does that weigh against deciding the issue now? I don't know that. I think that what's clean about this case is it's in front of the court on separate days, separate acts of malpractice, separate, from our perspective, occurrences. One injury. So you get, it's a in many ways, it's a clean decision.
Last one.
Yeah, please.
The proximate cause, just if you can just wrap up for me, Senior Justice's question on proximate cause, because it also seems you're sort of glancing over that because it's injury to a damage. And that proximate cause to me is being lost.
I don't mean to lose that because I'm very comfortable that, as with any, I mean, let's talk about our jury instruction definitions on cause. It does not have to be the only cause. It does not have to be the cause closest in time to contribute to the cause. So New Mexico very clearly takes the position that there can be multiple proximate causes for one injury.
That's a jury question.
Well, but that is understood.
That you need a record to have this issue decided.
Well, it is a jury issue ultimately.
The superintendent of insurance, whether they participate or don't participate, we have no record of that one way or the other.
You're right that proximate cause is ultimately a jury question. My reason for citing the jury instructions is not to muddy the water, but to say that in the definitions of proximate cause, the definitions of a cause of action, the definition takes into account that there can be multiple causes for a single injury, but that does not in any way change the fact that there are multiple acts of malpractice and multiple occurrences that come together to.
So this is what his questioning also has my wheels turning. So in my mind, I guess the purpose of at least in 1976, from what little we can gather, the purpose of the Medical Malpractice Act was to ensure we had health care for New Mexicans and also adequately compensate victims. Because at that time there was believed to be a crisis with insurance and all of that. So I keep wondering in my head, like, I just have a hypothetical. Victim A has the exact same injury as victim B. Victim A's injury is caused by the malpractice of one provider. So that means they get up to $600,000, no more. And victim B injury is caused by 3 providers, so they get the 1.2 million, even though they're suffering the same injuries, the same pain. Do you think that's what the legislature intended? And that's where I'm having a trouble.
Sure.
Like, I'm trying to understand why it's not by injury.
And victim 3 is a person with all the same things, but they were injured by a healthcare provider who's not covered under the Medical Malpractice Act, and their damages are unlimited. So it's almost an equal protection argument. And I know this court has been reluctant to say that the Medical Malpractice Act is a violation of equal protection, even though in your scenario, 3 different patients have the same injury, but they all 3 have different amounts that they can recover. I think that what you get back to answer your question directly under the Malpractice Act is each of those 2 providers paid for their own insurance coverage. They paid both for their underlying insurance, and I know I'm out of time. If I may finish. May I finish? each individual provider paid for their own insurance, their own underlying $200,000 in coverage. And each provider also paid surcharges to the patient compensation fund for an additional $400,000. So what per occurrence does in this court, it doesn't discriminate against patients, but what it does is it affirms that we are going to recognize that the medical healthcare providers are entitled to the full coverage that they paid for, and per occurrence references malpractice claim, which is an act by a healthcare provider.
All right, thank you.
Thank you.
All right, thank you for your arguments here today and being responsive to many a question. The case will be deemed submitted to the court as of today, and we'll get you a decision as soon as practicable. Thank you.
Move forward, please.